Engagement of contract-based workers and fixed-term employees across industries has seen significant growth over a period of time. In this regard, I have with me today Anirudh Mukherjee, partner, employment and corporate law. I'm hoping that he is going to shed light and educate me on employment law burning issues. Anirudh, my first question to you is, with the evolving workplace dynamics, what are the key trends that you've observed among employers in India regarding their approach to the workforce?
Thanks, Reena, for having me here. So, in respect of your question, in the context of the evolving job market in India, employers are increasingly adopting diverse approaches in order to manage their entire workforce. While the technically on-roll permanent employee population continues to remain the substantial part of any employee population, there is a ever-growing trend of employers now starting to rely on third-party contract-related workers, on fixed-term employees, on independent consultants for different areas and different aspects of their organization. When we spoke to a large number of employers, and they mentioned the fact of the ease of administrative burden, ease of statutory compliances, the overall ability to have a flexible workforce as the primary reasons for adapting to this kind of a technology, this kind of a process. We have seen in the recent times a lot of employers rely on fixed term employees for specific seasonal, if the work is seasonal, or for specialized projects. We've also seen employers look at contract workforce from third party agencies for non-core activities of their establishment, and look at independent consultants for specialized areas where they need short-term but specialized workforce, therefore avoiding the entire concept of having a direct employment engagement. At the same point in time, we're also seeing a movement which is growing from the side of these contract workers or fixed term employees to plead for equal rights vis-a-vis the permanent employees that the organizations have. We're seeing all these trends. So let's see how this goes forward.
So, is there any legislation which applies to contract workers or outsource employees?
Yes. In India, we have a legislation by the name of the Contract Labor Regulation and Abolition Act of 1970, which is the primary legislation which deals with the rights of the contractual workers, the obligations of the contractors, the principal employers. What is interesting is that while the CLRA clearly states out the rights, the obligations of the parties, it does not address the fact as to how the contract workers would have equal rights with respect to the permanent employees in the establishment where they contracted out to. However, we have recent times seen the judiciary come into play, and there was a case where the BHEL Workers Association went up against the organization to the effect where the Supreme Court stated that contract workers who are doing the same job or same process as that of the permanent employees of the employer are entitled to the exact same conditions of work, service conditions, whether it be wages, social security, hours of work, leaves, etc.
That's really heartening to hear that, our courts are looking into what, the needs of the contractor and the temporary workers.
Right.
So, Anirudh, I wanted to know, under the CLRA, what are the potential implications for the principal employer if a contractor fails to fulfill its obligations?
Interesting point, Reena. The CLRA actually puts the obligations on the contractor in the first place. Obligations such as ensuring timely payment of wages, ensuring the availability of basic facilities, etc. And what the CLRA does is that in case the contractor is unable to, for whatever reason, fulfill its responsibilities, it requests or requires the principal employer to step into the shoes of the contractor. And then the principal employer is statutorily bound to ensure that timely payment of wages, ensure payment of social security to the contract workers, work timings, conditions, etc. And in case the principal employer incurs any costs in this regard, it is statutorily entitled to recover the same from the contractor. So the law with the intent of protecting the interests of the contract worker, provides for this sort of a layering. This has also been recognized by the courts in India. So we had the case where there was this case by the name of, I think, People's Union for Democratic Rights, which the Supreme Court came down and established the principle to state that any time the contractor is unable to fulfill its statutory obligations vis-a-vis the
Mm,
contract workers,
mm.
the principal employer is bound by statute to step in.
Okay, very interesting.
Yeah.
Anirudh, I've been reading a lot about this Ola sexual harassment case.
Yes, of
Could you
course.
tell us more about it?
So interesting case,
Yeah.
because historically all these aggregators have been working on the independent contractor model, where the drivers, the riders, as the case may be, are all engaged as independent contractors, and there is no employer-employee relationship, which is one of the requirements when you are required to put a case under the
Yes.
POSH Act,
Yes.
or the Prevention of Sexual Harassment at
Mm.
Workplace Act. In the case of Ola, the facts were that this lady had used the Ola app to
Mm-hmm.
hire a taxi, and during the ride, she faced obscene gestures and other
Oh
behavior
dear.
which was not appropriate with the driver. When she raised this complaint with Ola, Ola pleaded the fact that there is no direct employer-employee relationship. They suspended the driver. There was some mentioning about driver swapping, and said that, that's it. The lady was not absolutely satisfied with the fact that, the only thing they've done is suspended the driver, and therefore approached the court. The court in this case, it's one of the first instances that we're seeing this, went into the concept of where is the control factor lay. They established that looking at the entire contractual framework entered into between Ola and the independent contractor or the driver, the entire control over the activities of this independent contractor, whether it be which rides to do, what are the timings, how much is the ride sharing fee, and all other established rules and principles that govern the entire job profile of this gentleman, were governed by Ola, and thereby establishing the control of Ola over the driver and reading into the progressive nature of the POSH Act, which intends to secure women against sexual harassment at the workplace. The court held there to be an employer-employee relationship for the purposes of the POSH Act, and also ordered compensation by Ola to the lady. This, of course, has gone into appeal, and the appeal is expected to be heard later this month. So let's hope that these principles are held properly and in favor of the.
Oh, that's really interesting because there are so many businesses which are software-based businesses
Yes,
where there are the similar types of models,
true.
and I think if companies can get away by saying, these are not my employees, I mean, it's going to be,
No, it is very important that in light of all these decisions and judgments that we were mentioning,
yeah.
that employers really need to relook at their entire contracting structure as well as their employee framework to ensure that they are not only in paper on paper but in concept actually compliant with the laws that are relevant to them.
No, no, this is very fascinating. Are there any other judgments you can tell me about which you think are going to have a very significant impact in times to come?
Interestingly, Reena, that's a great question. Uh, Recently, we were reading about a case involving IIT in Bombay, and how they were ordered to pay gratuity to contract workers who had been engaged through third party agencies with IIT Bombay. The distinguishing factor that the Bombay High Court brought into this was the fact that while there were different contractors through which these people had been hired over times, they were the same people working for almost the past 26 to 30 years with IIT Bombay through different
I
contractors.
see.
So the court actually held that the ultimate control over the establishment where these people are engaged was with IIT Bombay, which um, would require a large number of employers who use contract workforce to actually relook at the contracts that they're doing and the process that they're following while engaging contract workers to ensure that the contractor remains the effective employer and the principal employer is not held liable on these.
So I think the courts are stepping in to protect the workers and
Yes,
obviously going with the intent of the law.
absolutely, absolutely true.
So Anirudh, I think this is really what we are hoping for from the courts, that they take a holistic view, they look at the intent of the law, and they make sure that the people who need to be protected are in fact protected. And I'm really happy to hear what you have explained to us. Thank you so much for your uh, enlightening remarks.
Thank you for having me here, Reena. It's
Sure.
been a pleasure.
Thank you.